ready whenever you are.
Good morning, Your Honor. May it please the court. My name is Barry Wilkinson, and I'm
You can reserve 5.
I'm sorry, I was going to do that next, Your Honor.
Okay.
Reserve 5 minutes for my
Okay.
rebuttal, please.
All right.
We are here representing the homeowner, Terry Petrie. And Terry Petrie wishes to get this court to reverse the trial court's erroneous summary final judgment of foreclosure. Your Honor, I sort of presume that you're familiar with the facts, but I want to make a point that the complaint in this case was filed on October 23 of 2015 by Kirkland Financial LLC. And in that complaint, they pled that they were the owner and the holder of a promissory note and a mortgage that was signed by Ms. Petrie in 2007.
Can I stop you there for a second? I think we understand that, and we also know that Kirkland's successor, Wilmington, or either Kirkland, filed the original note that is, you would agree with me, identical to the note that's attached to the complaint, and even has more in it. So there's a case on point that talks about if you file a note that's identical to the note filed in the complaint, there's a presumption that you own the note. I want you to talk about the court's imposition or application of judicial estoppel, because what you're arguing to us, you were not able to argue below because of judicial estoppel, right?
It was argued below.
I feel like you're getting ready to argue me lack of standing. But you weren't able to argue that below because the judge found you were judicially stopped because your client filed for bankruptcy with an intent to reaffirm. And the court said, because your client didn't reaffirm, she surrendered the property, right?
That is what the trial court held, Your Honor.
Okay. That seems to be the issue, doesn't it? Because if we were to reverse, you could go back and argue standing, couldn't you?
We hope to, Your Honor.
Okay, so tell me how the court was wrong doing that.
That's relatively black and white, Your Honor. The trial court here is a Florida Circuit Court, and it looked at an order that was entered in a 2011 bankruptcy case in St. Louis. And the case of St. Louis Chapter 7 only said that because there was no enforceable reaffirmation agreement, that the court lifted the stay. When Ms. Petrie files her Chapter 7, the creditor, whoever claims to be the creditor, is not permitted to enforce their rights. This Chapter 7 court never said that the creditor, RESI, R-E-S-I, had the right to enforce. The bankruptcy court said, we don't see a reaffirmation agreement because the bankruptcy court has to approve
Right.
a
But let me ask
reaffirmation
you
agreement.
this, are the filings in the record the complete bankruptcy case?
No,
Okay, help me out, I didn't do bankruptcy law, but if you've got an order of discharge, it seems to me that there's a schedule of property that's secured debts that are discharged, is that correct?
that is correct.
Is that in the record that the secured debt on this particular real property mortgaged and owned by Ms. Petrie was discharged?
It is in the record that the personal obligation is discharged. Yes.
So that's what they're arguing is the fact that she reaffirmed but failed to reaffirm and the debt was discharged, she's barred from contesting the foreclosure.
That's what the trial court ruled.
Well,
That is certainly not bankruptcy law, Your Honor.
help me out also, because if she was discharged in bankruptcy on this debt, how is the lender bringing a foreclosure action?
The lender is entitled to enforce the mortgage if they can show that they hold the note.
Okay,
The-
so it's really just simply a question about extinguishing the mortgage on the property to clear the title, not about holding your client accountable on the note.
Well, my client can't be held personally obligated at
Because
this
she was
point
discharged, right?
because of the discharge.
Okay, so then the corollary of that is your client has now been discharged on the note, but wants to hold on to the property.
She wants to reaffirm the note.
Well, she had that chance.
No, she didn't. Nobody ever.
Well,
Well, I'm sorry, Your Honor, I don't mean to stop.
well, no, that's okay. No, no, this is a good dialogue though, because it's helpful. Because she basically said she wanted to reaffirm the note in bankruptcy,
She did that in writing, filed that intention timely with the court.
but nothing happened. Or no reaffirmation agreement ever materialized.
Right.
Okay, whose fault is that?
In my view, it's the creditor's
Well,
fault.
I knew that would be your view, but let's be fair about it. Didn't she have some obligation to say, hey, I've reaffirmed and I'm ready to do that? I mean, apparently that didn't happen. Apparently she sat quietly by, waited for the lender to do something. The lender didn't do anything. And the bankruptcy discharge happened, the case was closed, and she went on down the road. So the untenable position that you're taking for your client, though, is she's been discharged on the debt, yet she wants to keep the property.
She does.
Well, I want that deal too. You know, everybody wants that deal. I don't have to pay the mortgage, but I want to keep the property.
She never said she doesn't have to pay the mortgage.
Well, she
Well, she
got
has.
discharged on it, so she's not legally obligated on the note.
What she has said all along is that she wants to reaffirm the obligation with a creditor that's the correct creditor. And that's back in the standing
Well, that
position.
was the opportunity she had in bankruptcy, right? I mean, she could either redeem, she could reaffirm the debt, she could surrender. She chose to reaffirm. And the bankruptcy code, which she's supposed to have knowledge of, she's supposed to do one of those three things before the discharge. And she didn't. So isn't that constructively a surrender of the property?
That's certainly what was argued by this substitute plaintiff, Your Honor.
Well, let me ask you this. If, I think it's the Rodriguez case where the creditor actually goes into the bankruptcy and asks for relief to compel the surrender of the property.
For the reaffirmation.
Or the, yeah. And so isn't that, I mean, I suppose that's something that could have happened here, but the lender chose not to. They chose to go off and do the foreclosure action.
What the trial court completely refused to acknowledge, and what this court is working its way up to refusing to acknowledge, is that when the bankruptcy was closed, when she got her discharge, the 2009 foreclosure case was still pending in Hillsborough County. And the
Why would that matter if she's discharged from that debt and doesn't legally owe her? Why would it matter?
she's obligated on the mortgage. She's going to lose
Well,
her
she
house
didn't
if
pay
she
it
doesn't.
because you admitted she didn't pay it in your pleadings.
Well,
She admitted that it was
yes,
fault.
she has not made payments. She's not quite certain who to make the payments to.
I didn't expect you to talk yourself into your client being discharged and the court. It seems to me if she's claiming to be discharged, she's not legally responsible for this mortgage. How should she be able to contest it?
She wants to be responsible for the
Well,
mortgage.
wait a second, if he wants to be discharged, this happened in 2012. He got sued in 2017, now it's 2022. I mean, this is 10 years. She's been trying to tell me that she wants to sign a reaffirmation agreement for this 10 years.
She does.
I think Judge Smith has a point because every single bankruptcy case that surrenders the property to a creditor surrenders the property to the secured creditor. So, but also the bankruptcy cases say the debtor cannot retain the property if they do not redeem or reaffirm. She did not reaffirm, so the bankruptcy court says she can't hold the property.
That's not at all what the bankruptcy court said. But
That's what a case says. It's called Fiala and Taylor.
Fila and Taylor both involve agreements to surrender.
No, but
Do
they
not
also
agree.
say you can't retain property if you don't surrender, and you don't file an exam, and you don't redeem, and you don't reaffirm, you can't retain the property in bankruptcy.
You're on the
Because bankruptcy is a gift.
Say what?
Bankruptcy is a gift. It is a privilege by law. It's a give or take. You're saying I can't afford this stuff. You're saying I can't afford this mortgage, you gotta give it up in order to be discharged.
Your Honor, she never said any of that. In fact, she made a reaffirmation agreement with the original creditor.
Where is it?
Pardon me,
Where is that?
it's in the court file.
There is no reaffirmation agreement in this court file, sir. I scoured it, trust me.
Your Honor, I can show you the page number because I filed it with the court where she entered into an agreement with the original creditor.
American Home Mortgage,
No,
that's the creditor she listed in bankruptcy. That's the creditor that she swore she would reaffirm the debt with.
And maybe I overlooked it in your brief, but I don't recall you ever saying that anywhere in your brief. Your position was the bank should have come forward with a reaffirmation agreement and they did
after
not.
the bankruptcy. Before the bankruptcy, she filed with the court.
Which
For-
court, which court?
I'm sorry,
You're saying she filed with the court. Can you specify what court she filed the reaffirmation
yes,
agreement
Judge,
with?
I surely can. In the foreclosure case that was filed in
The
2009. The foreclosure case that was begun in 2009. The foreclosure case where the original note and mortgage was filed with the Hillsborough County Clerk in 2010.
But the court, see, here's the problem. We can only review what's in the record.
This is in the record.
Oh, no, it's not.
Beg
Here's
your
why.
pardon.
Here's why. Here's why. You filed a notice for the trial court to take judicial notice of that exact file you're talking about. The court denied it.
They didn't deny it. That's one of the things we're really unhappy about. The trial court has an
Counsel seems to have
obligation.
an issue with that because I have an order in my stack here where the judge denied it. Judge Nielsen denied your motion to take judicial notice of the 2009 foreclosure.
With
Are you
respect,
telling
sir,
me that's not true?
that is not true.
Okay.
What I would like the court to understand is that we had a hearing on the homeowner's request for judicial notice, compulsory judicial notice. And at that hearing, I argued on behalf of the homeowner that she's entitled under compulsory judicial notice, 90.202 and 203, that says the court is required to take judicial notice when she's met the criteria and told the other side that's what she wants. And in the same statute, 90.205 says, if the trial court decides not to grant judicial notice, it has to promptly advise the person requesting judicial notice. Because that means that the litigant has to do something to prove those facts. The court never denied Ms. Petrie's request for judicial notice.
Well, now you're saying they never denied it. Was there a ruling?
No,
That's your responsibility to get a ruling, sir. That's your responsibility to get a ruling on your motion.
that's certainly true, Your Honor.
Okay, then, so it's not before us. There is no adjudication, no judicial ruling below where he granted your motion to take judicial notice, correct?
Correct.
Okay. Let's move
And
on.
there's no judicial ruling that says he refused to take judicial notice. He remained silent, and the court's not allowed to do that, Your Honor.
Well, it's the
statute
duty,
says-
it's your duty to obtain a ruling from the court for preservation purposes, so we could properly review it to see if the judge erred or not.
I got the hearing on our motion. I filed a motion for rehearing. The court just ignored it.
Well, I mean, if the court ignores you, and then it's the obligation of the attorney to bring it to the court's attention and set it for hearing and obtain a ruling. So, and otherwise, I don't know, how are we to review that?
I would respectfully suggest that the trial court made a mistake and that your whole existence is to correct mistakes made by the trial court.
But that would be your speculation, because we don't have an order on it.
We don't have an order, but the trial court is not permitted to simply ignore a request for compulsory judicial notice. They have to say yes or no. They can't just ignore it. That's a mistake if they ignore it. And it's a mistake that this court has the ability to correct. And Your Honor, the complaint that was filed October 23rd of 2015 by Kirkland Financial claims that they can prove standing based on their 4 Mesne assignments. And the first assignment took place in 2011, the second one in 2012. And during that time, this note, the note at issue in this case, was held by the clerk of the circuit court for the benefit of the plaintiff in the 2009 foreclosure case.
You're at 15 minutes, sir, just so you know, it's your time, though you can use it any way you want.
No, Your Honor, I want to save the last 5 minutes.
Okay.
Thank you, Your Honor.
Please, the court, my name is Jennifer Chapkin. I'm here on behalf of the Appellee Wilmington Savings Fund Society, FSB. Your Honor, I believe that you alluded to much of my argument during your questioning of appellant's counsel. It is true, the copy of the note attached to the complaint does bear a blank endorsement. There's a certification of note possession, regardless of any assignments, and we later filed the original note in the same condition in compliance with the case law.
But I think we're struggling with the issue about what happened in bankruptcy court and how it relates to this foreclosure.
Absolutely. So the appellant is putting the cart before the horse with his standing arguments, because the trial court did properly rule that appellant is judicially stopped from contesting the foreclosure action, because doing so would be taking a position inconsistent with her bankruptcy
And
filing.
how is it inconsistent? The position, right, is reaffirmation. I want to reaffirm.
Right.
Okay, it didn't happen.
It didn't happen.
Okay, but the cases that you rely on are factually distinguishable to me, because there, the debtor below said they were going to surrender. And so I realize the whole constructive argument that that's in effect, if you don't do it by the time period you're supposed to do it that the bankruptcy code says, then in effect, you basically surrender the property. I get that part of it. But with respect to judicial estoppel, I don't see the inconsistent, position she's taking, because she wanted to reaffirm. She's saying she wants to reaffirm. Sounds like the same thing to me. And the other cases are surrender, which are completely different than reaffirmation.
Your Honor, in both the Ingray Jones case and the Bank of America versus Rodriguez case, the debtors there in each case indicated a intention to reaffirm within their schedules and then failed to do so. And in
Or
both
those
cases,
judicial estoppel cases.
they were not judicial estoppel
Right.
cases, because in both cases, the debtors went
And
back
that's
to
my
sue.
issue.
to sue.
Is judicial estoppel the right mechanism here to preclude this claim? So, and maybe it's the lender should have gone off like Rodriguez did and filed in bankruptcy, but you're here in the circuit court under a judicial estoppel.
Right, even in first, the bankruptcy court, I mean, Ingray Alcoby actually states this, that the bankruptcy code actually does not define the term surrender. It has to look towards the actions of a party. Now, appellant contests throughout this appeal that and represents that she indicated an intention to reaffirm, but was never provided with a reaffirmation agreement. In the bankruptcy code, there's nowhere that requires a creditor to provide a reaffirmation.
I
that's not
agree
even
with you on that
in
point.
there.
She's on notice of what the law is. She's on notice of what the code is. She didn't do what she said she was going to do. But how do I get to judicial estoppel?
Because they cannot, the appellant cannot be allowed to both remain in the property and not pay anything, not surrender it, not do anything while getting the
Help me
benefit
out
of the
with
discharge.
the elements of judicial estoppel. How
Well,
does she meet each of the elements?
she's taking a position, she's judicially stopped because she's taking a position that's inconsistent with what was in the bankruptcy court. It's really making a mockery of the court system by saying, I intend to reaffirm, and then later go on and say, I'm not going to do that at all. I suppose it's collateral estoppel.
Well,
perhaps.
she's seeking to defend a mortgage from
Right.
which she's been discharged.
Correct.
She has no legal right to the
She
mortgage.
has no
anymore.
legal right to do that.
Basically it, yeah.
That's it.
That's where I want to land for a second, because I've gotten up to speed on bankruptcy law with respect to this issue. Much of it is surrender, but there seems to be leaking over into, if you fail to reaffirm, it constitutes a surrender. But the common thread through all of these cases is it gets surrendered to the secured creditor, and it gets surrendered to the creditor that he or she identified and swore to surrender. Those are all issues, and those were causing me concern. Let me finish, I talk slow. And that was causing me concern. But here I am sitting in oral argument with a party who now says, I am discharged, I am not legally responsible for this debt. So how can she legally defend that debt is question one. Question two is, do you see any tipsy coachman in this at all? Because if there was judicial estoppel was imposed or applied, was Petrie still allowed to argue about lack of standing? And did you introduce enough evidence to prove the elements of the foreclosure? This, regardless of that.
As to your first question, I do not believe that she could legally defend. The case law, and it's recent case law that's come out of the bankruptcy court and the district courts, both at the appellate level and the trial court level, that she cannot legally defend the foreclosure
I mean,
after she's gotten the benefit of the discharge.
doesn't Bank of America versus Rodriguez out of the Southern District of Florida in 2016 stand for this proposition that
Yes.
if she basically fails to perform one of those three options, that she effectively surrenders the collateral?
She
I mean,
does.
it's not binding on us, but it's certainly very persuasive.
She does, and the Florida State Legislature has recently implemented a new statute, Florida Statute 702.12, that provides a mechanism for lenders to proceed with enforcing a bankruptcy surrender as a different way of filing a complaint. I personally haven't done it, but it authorizes lenders to do it and say you could go back and get the collateral, you have to send a notice and proceed, and you could go back and get it that way. But what Meltzer says is that even if the borrower surrenders the property, the lender still has to do something to enforce it, whether you go and file a foreclosure action or you go and you get it back from the bankruptcy trustee. So there's two different mechanisms via which the lender can then get the property back. The borrower doesn't just go and walk up to the creditor and say, here are my keys, take my house. So there still has to be a statutory mechanism via which the bank does it.
So if we don't find judicial estoppel, then you're saying we can affirm under Rodriguez?
I think you could affirm under Rodriguez. I also think that regardless, the bank still demonstrated, to answer Judge Sleet's question, that there's ample evidence regardless for standing here, because plaintiffs still possess the original note, the top copy of which is attached to the complaint, and filed it in the same condition with the court prior to summary judgment. So let's say the court does say, you know what, we're gonna unwind that and you're gonna be allowed to contest plaintiff standing. Plaintiff still demonstrated standing by virtue of its possession of the original note endorsed in blank, later surrendering it to the court, and by virtue of the mezzanine assignments that sign both the note and mortgage. So no matter what, judgment should be affirmed. And I understand that this is complicated. I'm not that adept at bankruptcy either, and I had to delve into it to find the cases and make the arguments. But it is becoming more common for creditors and lenders in foreclosure actions to go back and enforce the what a debtor puts on their statement of intentions, because they can either redeem, reaffirm, or surrender. And then once that's done, they cannot do nothing.
Let me ask you a question then, because my question was, can we do it under Rodriguez? But Rodriguez was in a different forum. I believe it was in bankruptcy where they did the motion to compel, right, to surrender the property.
Right, but what?
So I don't, does the circuit court have the ability?
Yes, Because
Tell me
what-
what case gives the.
what Meltzger and Wold
Okay.
say is that the creditor could either go back to the bankruptcy court, or
Right.
they have to take some action,
Okay.
which can be going and proceeding in the foreclosure action and filing a foreclosure. So that, and now with the new statutory mechanism, 702.12, it's clear that the legislature does intend to provide the creditors the right to go back and do a mechanism to enforce what a debtor puts on its statements of intentions. It's a complicated issue, it's very nuanced, but at the trial court level, it's happening a lot throughout the state of Florida. This isn't the first motion for judicial default and for judicial estoppel that I filed throughout the court. Other creditor firms are doing it. A lot of the cases that I've seen out of the 3rd DCA, 4th DCA, they just get affirmed without written opinion. So this one would be, other than the Lewis case that this court has previously decided, would really go into surrender of a property, constructive surrender of a property when a borrower included the debt that's subject to the foreclosure action on its statement of intentions.
So that's like why I asked the question earlier, Mr. Wilson, was because we have the Fisher case that we reversed because of a question of fact in terms of whether the bankruptcy records exclusively show the surrender of that particular property. And that's why I asked about these particular records. Do they clearly show that she reaffirmed the debt to this particular secured creditor who held the note?
Yes, and well, not this particular one, but the order granting the creditor's motion for relief from stay does give the bankruptcy creditor, who at that point I think was AHMSI,
Massey.
right, its successors and assignees in interest, gives them the right to enforce all rights to possession of the premises under the terms of the deed and trust, which is a mortgage. The bankruptcy was filed in Missouri, so they use Missouri terms there because it's a judicial foreclosure. It's not a judicial foreclosure state, and in accordance with applicable bankruptcy state law, including but not limited to all necessary foreclosure and eviction procedures. So it gives right to the creditor and any successors or assigns, and even Ms. Petrie, in her answer in affirmative defenses that she filed, she admits that this property was surrendered or was discharged in bankruptcy. So that's not a question. I don't believe that she cast doubt on whether the creditor in the bankruptcy was the proper creditor. If your honors have no further questions, I do believe that this issue is really cut and dry here. Either the order of judicial estoppel should be affirmed and the final judgment affirmed by virtue of the appellant's constructive surrender. And if not, final judgment should still be affirmed because plaintiff demonstrated its necessary standing to foreclose at inception of the foreclosure action in 2015.
Thank you very much. Yes, sir. You have 5 minutes.
Thank you, Your Honor. One of the things that the bankruptcy court record shows that the court took judicial notice of is that the wrong creditor lifted the stay. But it doesn't make any difference. When the bankruptcy chapter 7 is closed, the creditor is put in a position where they're allowed to enforce whatever rights they claim to have. On the day that the bankruptcy case was closed, and a week earlier when the stay was lifted, the creditor that claimed to be entitled to enforce the note was free to return to Hillsborough County Circuit Court. The 2009 foreclosure was pending at that time. It was halted by the filing of the chapter 7, but when the stay is lifted, the foreclosure can start up again by the creditor. And when the case is closed, the foreclosure can start up again by the proper creditor.
Well, at the hearing on June 19, 2019, you admitted to the court that Wells Fargo through RESI had standing ownership of the note, and that Wells Fargo would have prevailed in the foreclosure, and I quote, hands down, correct? That's what you said. So you conceded that RSI had standing. The MERS, the successor has to be after that. And in 2014, CB, filed motions to recover the original note. Bankruptcy court, or the trial court that served you with the order saying they had the right to enforce the note.
No, they didn't.
The order did.
The order said that.
Okay, but you didn't challenge that, and you were served with that.
We were not served with, it,
I
and that's
guess
part of
you
the
were.
brief. We were not
So you're
served.
very welcome.
Um,
Your own service.
We were not served. We didn't get mail service, and the email address in the order is wrong. You know, Your Honor, as an individual and as a court judge, that if the email address is wrong, you don't get it. It never comes. I didn't learn that the court had removed the note from the file, from the clerk's file, until the new foreclosure was filed. They didn't serve Petrie and they didn't serve me. That's not right. You said, I don't mean you personally, but this court said that while the legal court is required to remove the original note from the custody of the clerk has no authority to relinquish the note to anyone but Deutsche Bank. That was the original plaintiff in Deutsche Bank National Trust Company as trustee versus Noll, N-O-L-L. That's this court's ruling. And the court went on in another case and said, where here, when the defendant asserts a lack of standing as a defense to foreclosure, it's incumbent on the plaintiff to prove its standing at trial. Then that means every single one of those assignments, they have to prove the validity of every single one of those assignments. And when the assignment takes place, allegedly takes place, while the original note is in the possession of the clerk of court is holding it for the plaintiff that filed. That was Wells Fargo. And that case is Dixon versus Roosevelt Properties. This is your ruling, your court's ruling. I don't mean you personally, of course. But throughout this case, even in the foreclosure case in 2009, there was an issue of who had standing to foreclose. Judge Little dismissed the case, dismissed the complaint with right to refile in 20 days if they were going to fix who had standing. At that time, both Wells Fargo and SunTrust claimed they had standing to foreclose the note. Each of those two creditors had sent demand letters to Ms. Petrie. The reason Judge Little dismissed it then, because there was an issue about who had standing. This court can see that this note and mortgage had been transferred many times. And in order to properly foreclose a homeowner's interest in real property, the plaintiff has to prove standing. That's been there since forever. I mean, that's what this court has said, the Florida Supreme Court has said. Thank you for your time, Your Honor.
Thank you.
Thank you very much. Thank you both very much for the presentation. Next case is ADS Building Contractors versus Victor